Welcome to episode number 32 with Tony McFarland, an attorney and an expert in the fast-moving and ever-evolving data security and privacy law.
I'm going to coin the term of CISCO, CISCO.
Oh, that's cool. CISCO, CISCO?
CISCO, Chief Information Security and Compliance Officer. And that he or she will be responsible for that area because they are indistinguishable. Certainly there will be people on each side of the house, so to speak, who will focus on one side or the other. But from a board perspective, a board is not going to want to distinguish between a compliance report and a data security report. They want to make sure that the company is in compliance with the laws and regulations and ordinance that govern the company, and that its intellectual capital is preserved.
Hello, and you are listening to Bill Murphy's Red Zone podcast. If you are listening for the first time, I interview leaders who inspire me in the areas of hardcore IT security, IT business leadership, innovation, creativity, entrepreneurship, and fearless living principles. Welcome to the show. Welcome back to the show, everybody. This is Bill Murphy, your host of the Red Zone podcast. Today, I had an interesting conversation with Tony McFarland. Tony is an attorney, one of the best in the United States at understanding the fast-moving and ever-evolving data security and privacy law landscape. Tony has a very unique perspective that comes from working with the top, with CEOs and boards. So if you are an IT leader in any capacity, and our conversation will help you understand what the top is asking for, at least what they're trying to ask for. Boards and CEOs are better educated now, and I asked Tony what the top 3 questions he thinks every board and CEO needs to ask from their IT security leadership and their general IT leadership. So what makes up the elements of a board presentation? What are the trends in privacy? What are the trends in privacy between Europe and the United States? I didn't realize the First Amendment impact on this cyber privacy battle between the Camp 1, which is the right to be forgotten, versus Camp 2, the public's right to know. The difference between European privacy law and the US, and really the underpinnings related for the US side all the way back to our founding fathers. So in addition to this, what does the SEC consider a security breach, and how do you disclose it? Should you disclose it? And what are the SEC's expectations regarding attempted breaches and breaches? So we also cover the concept of which I find really interesting, the rise of the CISCO. So not the company Cisco, but the Chief Information Security and Compliance Officer. He thinks that CEOs and boards are going to be less inclined to want information from multiple camps, from, for example, the CIO and the CISO, and want more of a focus coming from one camp, one voice, which he calls the CISCO. This is an interesting point I find worth listening to. So visit the show notes at redzonetech.net/podcast, where there'll be links to all the published material, all the show notes, all the links that you may want to further learn more about Tony and his published material. So it's now my pleasure to introduce to you my conversation with Tony McFarland. It's a pleasure having you on the show, Tony. So I want to welcome you to the show.
Well, I appreciate the opportunity to speak with you today, Bill.
Well, one of the things that I am intrigued about, and I think we got connected because we found you're one of the top cybersecurity attorneys in the United States. And I know that's a broad term. Cybersecurity law covers a lot of areas, but I'd love for you to talk about, what do you say when someone at your firm or even casually says, what do you do for a living?
Sure, and I must sort of start by saying I've got to give a hand to my business development folks if they've managed to sell me as an expert in the entire field of cybersecurity. But what I would do here at the firm, for instance, I'm the head of the technology committee, the technology partner, and over a period of years, the committee has become less important, and it's essentially me and the head of our information technology group and the executive director of the firm who make the decisions subject to the managing partner. And I view my role between the lawyers, my law partners, and the IT staff and my head of information security as being one where I'm the interpreter between the two. Essentially, I need to fool both sides. The lawyers need to think that I know enough about technology that they're prepared to put those decisions in my hands, and the information technology folks understand that I know enough about what's going on from the user side and what's palatable, particularly to the owners of the firm, as to what could be sold and what could be implemented, whether that would be the pristine information technology decision or not.
So if someone asked you that question external to your firm, and potentially it was a new Fortune 500 business, how would you explain what you do? How would you explain your unique niche, your unique expertise, what you would say you're world-class at?
I would classify what I do more than anything else, and the value that I would bring to a situation is the ability and the knowledge to understand and follow the developments in the entire field, which runs across, obviously, a number of regulatory areas, and the ability to understand enough of the way the technology works, not just the mechanics, if you will, of it, that I can provide counsel to, whether it's the CIO or the CISO or the general counsel or the CEO, of the risks that are out there and what is an acceptable standard of a level of risk in the industry that's capable of being accepted, particularly given the risk tolerance of a company, so that they can make their own independent best judgment about what they are and aren't prepared to do. Because, for instance, you can't spend your way into complete cybersecurity. You have to make some judgment calls, and that's what I view my role is, to have my clients, for instance, informed to the best of my ability and their ability to make a smart choice.
So basically advising them not necessarily to spend their way out and through IT security, but really look at it from a risk point of view.
Absolutely. And what my experience has been is that particularly with the CIOs and the CISOs, sort of in the lawyer's vernacular, they get it. They understand that you can't buy enough pieces of equipment and you can't hire enough staff to protect against all the risks, both external and internal, and judgment calls have to be made in the context of how the business operates, and they understand that. And in my view, properly implemented, the board, the CEO, for instance, of a company relies on the judgment of the CIO or the CISO because he or she has taken the technological aspects and put them into the way the business works and what the business can and can't tolerate, to provide counsel to the other management of what business decisions they should make.
So if you could do this, I'd like to get into some specifics about some areas I know are a concern for CIOs and top IT leaders. So I was reading some of your posts online, and one of them it had referred to, it was in the middle of the summer, the SEC said that all 10K filings moving forward had to be, I'm not going to do this justice, but basically had to disclose if they had been breached or knew of being breached or had knowledge of a breach. But as I read it, it became unclear to me. It seems like it was still up for interpretation what that meant. And maybe you could just kind of explain what public companies have to be aware of with SEC moving forward.
Sure, absolutely. That is a very fluid area right now, unsurprisingly. I've had a number of conversations with my securities partners on this issue because it's a little bit of damned if you do and damned if you don't. Unsurprisingly, and perhaps appropriately, the SEC errs on the side of disclosure. And that makes a lot of sense if you go back 2 years, let's say, to breach disclosures of large corporations, which at the time seemed to be aberrations and catastrophic. What's happened over time is that the number of breaches has increased dramatically, and in some instances it's just that prior breaches have become discovered. And so it's almost ubiquitous now that they're out there, and the expectation of the public, in my view, and a view of some of my partners, is that too much disclosure is a bad thing. It's almost as if it's the story of crying wolf. For an investor to be really interested in making his or her investment decisions, what they would want to know is whether a breach is material in terms of the business of the company. And to disclose every breach, I don't believe that that's what the SEC intended, and certainly not intends now. But that would be just frankly foolish and would provide little to no guidance to an investor and essentially make them numb to any disclosures. So it is a pure judgment call area. The piece of guidance that I would give, and that we do give to companies here, is that you should try to stay within the range of what other companies do. And that sounds a little bit like a cop-out, but it isn't, because there is a range of acceptable disclosures, and what you don't want to be is outside the norm.
Now, you don't want to be outside the norm, and the word material is a breach material for the business. So if you're an investor in the organization, what would that word mean to the investor? Is it material?
Sure, and I can give you an example. If you have a company that has 200, 300 employees, and one of the members of management is on a flight somewhere and leaves their laptop in the airport and doesn't find it again, and it's got sensitive employee information on the laptop, that could be material to that company. On the other hand, if a similar thing happens and it's a manager of a plant of GM in Nashville, Tennessee, that may not be material to an investor in GM, because the dollars, if you will, that are at risk because of that breach are small in terms of the value of the company. So it may be the same laptop essentially, and it may have essentially the same type of information about the same number of employees, but in the mix of information compared to the size of the company, and for instance, GM's ability to contain and quarantine the risk, that wouldn't be material to me if I'm trying to decide whether to buy or sell GM stock, but it would be on a much smaller company.
I was listening to one of the CIOs that I know quite well. He was at a HIPAA conference, and one of the lead person at HIPAA explaining a story about a hospital where one of the employees had lost their laptop, or had 40,000 patient records taken off of the laptop. They voluntarily reported this to HIPAA, and HIPAA did a bunch of investigation and gave them an $850,000 fine. And this is an organization that voluntarily self-reported. What does SEC say? Obviously, there's probably not a lot of consistency between these regulatory bodies. How would, for example, SEC respond to that?
I would start by saying that you're right. There would be a good deal of inconsistency in the response of the various regulators. I would start with the proposition that having a good working relationship based on trust between the company and its counsel, or either in-house counsel or its outside counsel, with the SEC goes a long way in helping the decision about has it acted in good faith in trying to remedy the situation, jump on it as fast as they could, and minimize the danger to the purported breach victims, and had they done the types of things in advance to prepare, plan, and be prepared to respond, that it's not different than the way the world works is that you're prepared to give someone a little bit of a pass isn't the right word, but you're prepared to give them a little more deference or leeway, leniency, if they have exhibited efforts to avoid this situation from happening. I may be familiar with the case that you're referencing, and part of the reaction to that might be $850,000 fine is obviously a significant amount of money. But the flip side of that is, had that information come out and not been voluntarily disclosed, it may have had another digit in the fine.
Oh, interesting. Okay. Interesting. And that brings out another point as well, because I'm sure people have asked you before. So when there is a disclosure, there potentially could be a brand impact to the business. And almost like from a disaster recovery point of view, it seems to me that our disaster recovery plans now should really account for stock price fluctuations that come to brand impact.
I could not agree with that more. When we discuss that, for instance, internally here at the firm, clearly we're more concerned, or certainly as concerned, with the impact on our business and our relationship with our clients of a potential data breach than even, for instance, the dollars that we would be out of pocket to help remedy the breach, because it's extraordinarily difficult to rebuild your reputation. And that's especially difficult with a public company because they are under requirements to disclose material events, even if it, for instance, would be impactful on their stock price, because they can't withhold the information if it would be material to an investor in a mix of information and need to be disclosed, realizing that could have an immediate impact on the stock price.
It's very much of a conundrum for businesses to the balance between absolutely doing the right thing for investors and really preparing ahead of time for the obvious consequences. It's almost like they have to build this into their financial modeling, and because in many respects, well, let me ask you this. Is there, in your dialogue with people, is it if they're going to get breached, or is it more like when you get breached, here is how you should do your planning now for that eventuality?
I would answer that this way. Regardless of whether you have been or will be or might be breached, you have to plan as if you will, and you need to be taking the preparation both technologically and from a compliance and a process and procedure standpoint, irrespective of the answer to the first question. I will say that the conventional wisdom, or certainly the cliche that's often heard, is that there are only two types of companies: those that have been breached and know it, and those who've been breached and don't know it. That's obviously an exaggeration. There certainly are a number of companies which haven't been breached and never will be breached. But the fact that you fall in that category is nothing that you can assure yourself of or guarantee.
Well, I was reading your top 10 list for things to prepare for. I think it was for financial institutions, and one of them was insurance coverages. And I'm not sure how deep you get into talking about insurance coverage with either your own firm or when you talk to your clients, but what are you seeing happening in the insurance arena with cybersecurity?
Sure. And while I'm not an expert in that area by any means, we have to deal with that internally here at the firm, and we've also been dealing with it for clients. It's an interesting area in that if you go back, let's say, 4 or 5 years ago, it was difficult and maybe even impossible to find cybersecurity insurance. And typically what would happen is there would be a scouring of existing policies to try to determine whether there could be any coverage for a breach, which could either be third-party coverage for claims by a third party against the company that had the breach, or first-party liability for breach notification expenses and business interruption losses, those types of things. However, as the insurance industry understood and recognized that there was a risk here to be covered, the policies began to be structured and made available. The problem, if you will, the first couple of years is that the insurance industry did not know how to price these. either for price, scope of coverage, amount of retention, or any of that. And typically, my observation was that most companies did not purchase it because the insurance policies had not matured enough to know what you were buying and what type of coverage you were getting and how to balance off the risk of the cost versus the coverage. The insurance companies have gotten a lot more sophisticated in the last couple of years. They've managed to get a handle on the scope of the risks. And what I've observed is that companies that examined and passed on cyber liability insurance a few years ago are now either giving it serious consideration or, in fact, are purchasing it because now they have a better handle on how much are they paying for what type of coverage, and specifically for the amount of retention or deductible, if you will, that they're willing to live with before they get covered for essentially catastrophic losses through their cyber liability insurance.
Now, just shifting gears a little bit I was interested in learning a little bit more about the European Union's safe harbor changes that I think were within the past 30 days. Is that correct?
That's right. There was the European Court of Justice about 2 weeks or so ago, 3 weeks maybe now, had a case before it that brought at issue the safe harbor framework that was relied on by European and United States companies to pass confidential information, EU residents, to the United States. And it's important to understand that the context is the requirement of the U.S. companies, for instance, to provide adequate protection of the data transfers. The safe harbor rule, or the safe harbor framework, was just, you might call it a get-out-of-jail-free card. It was a mechanism under which, if the companies could show that they were in compliance with the safe harbor framework, that was presumed to mean that there were adequate protections for the data transfers. So when the safe harbor framework was essentially invalidated 2 or 3 weeks ago, it didn't mean that confidential information or personal information could no longer be transferred. It just put people back in the position they'd been in originally of having to be prepared to justify the protections that they do apply to the data transfers. I would say what's particularly difficult now, and one of the big values of the safe harbor framework, is that the scope of personal data in Europe is much broader than what we would typically think of here in the United States. Obviously, it covers things like Social Security numbers and medical history and things like that. But for instance, in Europe, something just like an IP address can be considered to be personal data or personal information if it would enable you to identify someone. So that's not typically the type of information that we here in the States would take extra precautions for securing. And so in the context of transferring data across the pond, if you will, having the safe harbor in place enabled United States companies to transfer data securely with the blessing, if you will, of the data protection regulators in the EU without trying to justify every type of data transfer that it made between, for instance, its subsidiary office or a business partner in Europe.
So from just the mechanics of that, if there was a company that was headquartered in the UK, or let's just say a US-based company that had an office in the UK of 30 people or so, and there was an office manager in the UK that needed to get data to the HR of the main headquarter company, would that mean that under the old framework, they could, for example, send the information across their traditional network and have it encrypted, and it just would fall under the safeguard protection for safe harbor? But now, the way I understand what you're saying is that they have to justify to a much deeper level how they're doing that transfer of information?
That would be correct. And particulars of what would have to be shown now on securing the transfer of data are not definitive, and importantly, they're not necessarily consistent. Part of the ruling from the European Court of Justice that invalidated the safe harbor that's most problematic is that each of the member countries in the EU have what are called data protection representatives, the DPRs, and the ECU ruling, the Court of Justice's ruling, now requires a United States company, for instance, to get the blessing, if you will, of the DPR of each of the countries if data of the residents of that country is going to be transferred. So where before you had the safe harbor that would cover data transfer from any of the European Union countries to the United States, now you effectively have to get the approval or consent of the DPR of each of the country whose residents their data is being transmitted. So you can see, for instance, a company with an office in Munich, let's say, that has personal information, could be addresses, could be dependent information from individuals spread throughout 2 or 3 countries, particularly contiguous countries, would need to get the approval of the DPR of each of the countries before that particular information could be transmitted. And it's not typical, or for that matter realistic, to think that you would transfer the information of some of the employees for Germany, let's say, that you did have the DPR approval to the United States, but withhold the information for Belgium residents because you didn't have the Belgium DPR approval yet.
Wow.
I guess when I say what's particularly troubling is that one of the options that a company had before and still has is to enter into essentially standard transfer agreements that have sort of model data transfer clauses, and that is the most likely, the most prevalent way to comply with any data protection transfer laws until a new safe harbor framework is put in place, probably before the end of January of next year. But a difficulty, for instance, is there's at least the DPR in one of the German states that's taken the position that that's not enough, that even if you complied with and used these model clauses, that's invalid for the same reason the European Court of Justice invalidated the safe harbor rules. So if you had personal data of a resident of that particular German state, it's effectively impossible to transfer that personal data to the United States unless you exercise one of the other options, which is the personal consent of the individual, which is unlikely to be forthcoming even if it was practically possible.
Wow, it's amazing the impact of that European law and how, I can't say they're setting the standard, but they sort of are putting a stake in the ground of where they want privacy going for them.
And that's not atypical of the difference in the view of privacy in Europe compared to the United States. We place a high degree of importance on the privacy of personal data, but not nearly so much as is prevalent in the European countries. And if you think about it for a minute, the safe harbor rule was designed to cover the transfer of personal data from the EU to the United States, not the other way around. And that's because of the greater emphasis put on a broader scope of data, the privacy of a broader scope of data of the Europeans from the transfer of that information to the United States.
Yeah, some companies, it seems they're going to have to draw a line and say if the burden is so, they're almost going to have to raise their internal standards to the highest common denominator, because it might be just too costly to try to have an outlier to try to be compliant in one outlying region of the world, which may be huge for some companies.
That's right. The conventional wisdom right now is to advise your clients here. What we would do is first, in fact, use these model clauses in transfer agreements, despite whatever risk there may be of those being invalidated on the back end. It's still the safe way to proceed. And maybe more importantly, to do all the things that you otherwise would have done under the safe harbor framework, because if I believe it's the U.S. Chamber of Commerce and the EU equivalent that are negotiating the terms of a replacement safe harbor framework, may very well, I use the phrase grandfather, that's not exactly right, but may determine that the similar standards that were set forth in the original safe harbor framework continue to apply, and so you will have been found retroactively to have complied.
Oh, I see. Which would be good for a lot of U.S. companies.
Right, and when I mentioned this German state, it's clearly an outlier. To my knowledge, no one has followed it yet, but it's exemplary of the risk that's out there when there are no common ground rules.
Well, I do love this topic of privacy. It's something that I get pretty aggravated about with not so much, well, I guess the way I want to ask the question is, what do you think about this right to be forgotten? It just I guess this is more of a philosophy question than anything else. Maybe you have an opinion about it that is legal as well, but it seems to me that it's something that we're going to, at some point in the future, going to come up against this hard object called the right to be forgotten. What are your thoughts?
Sure, and I hark back for just a moment to the difference between Europe broadly and the United States. There are, in fact, the EU has adopted some rules for Internet protection for individuals, which is referred to as the right to be forgotten. And for instance, European resident that's within the jurisdiction of the EU can complete a form through Google, for instance, and ask that certain URLs be removed. And then Google reviews the request using some unknown criteria and balances the individual's right to privacy against the public's right to know, and then either will delink the information, or if they don't, there's an appeal process for the individual to go through a local data protection agency, and then if that agency disagrees with Google, then there's a mechanism for a further review. Obviously, none of that applies in the United States, and philosophically and constitutionally, one of the reasons is the primacy, importance of the First Amendment. And so, unlike in the EU, the public's right to know that is so cherished in the United States butts up against the right to be forgotten. So some of the protections that might exist in the EU are unlikely to ever be adopted in the United States, just based on our guiding principles, if you will. The difficulty, which I think you identified, is that the ability to be as invasive in privacy as currently exists didn't exist that long ago, and certainly didn't exist 200 years ago. And so the issue, from a lawyer's perspective, is how are you going to balance the rights of the individuals and the press, for instance, of the right to know, which clearly is important and serves a valuable purpose in our government, with an increasingly invasive and intrusive ability to disrupt an individual's life.
Yeah, this is one of these topics that is, I think, going to just gain speed. And I can't say I have the perfect solution, but I think there's a case in front of the Supreme Court right now that's being decided in November. And this is heard. Someone shared this with me. Actually, this was the CIO of the Legal Association of Universities, but it's based out of Washington, D.C. So he's the CIO, and he was saying that from a privacy point of view, there's a company that is right now, I guess, gathers information from all different sources about an individual and sells that information to HR departments of major companies. The information was gathered surreptitiously without the normal, well, I would say, I don't think there is a word for normal right now, but it's going in front of the Supreme Court. And I found that very interesting because the data brokers are gathering the data and without really knowledge are profiting from this wide swath of information about people. And at some point that it seems like that's going to hit a groundswell of public unrest.
I believe that that's accurate. And part of again, this is my personal view, that when people immediately think about a right to privacy, they're thinking about, you are taking something away from me that's personal to me, which to a layperson, for instance, sounds like a Fourth Amendment unreasonable search and seizure. In the law, it is not that, but there is a concept embodied in that constitutional amendment that the principle seems to apply to this situation, where there has always been a balancing of a right to know and a right to not be known, if you will. And it's coming to the fore more than before, just because of the developments of technology. Things that you never could find out before, the Supreme Court didn't have to deal with because it never came before them. Now there's precious little that's not known or can't be known.
This must be a huge challenge in your industry, just being an attorney. And again, I don't know a ton about law, but I should probably phrase this as a question, is in most practice areas of law, do you try to reference a case history of precedents as you build your case? Is that the normal practice?
Ideally, yes. Practically, no.
I guess not in this situation, right?
Well, that's right. And I would say in this respect, there are obviously federal laws and regulations and cases, and then there are state laws and regulations and ordinances and cases. And depending on what the issue is, either or both of those could comply. And the best example that I can give is, I'm a resident of Tennessee here, and what we typically find as lawyers here is there is no guiding law. The value we bring to a transaction or to a dispute is to try to best guide someone through the absence of any rules or conflicting rules. So to say that we would start with trying to advise a client of acting consistently with the law, the answer to that is yes. But knowing if there is a law or what the law is or what the law should be, because obviously the law should change often and does change, is the value that a good lawyer and a knowledgeable lawyer would bring to a particular situation.
By the way, I did find the name of that company. It's called Spokeo, Spokeo, and it's like decisions on November 9th. And I just made note of it because it came up, and serendipitously we're talking about a similar topic. So very, very interesting. So one of the questions I have is about boards. So you obviously have, not obviously to our listeners, but from reading about you, some of your writing is about clear communication with the boards, and the boards no longer can deflect or give the Heisman, metaphorically, stiff arm to issues related to cybersecurity. So what's your observation been with IT leaders communicating with a board, and also the inverse, the boards communicating with IT leaders?
Sure, and you should put it in this context that 10 years ago, having a CIO or a CISO position would have been rare, except in the largest companies. As technology has developed, and I usually prefer to use the term data security rather than cybersecurity, because it's the protection of the assets, the intellectual property assets of a company. As that has become more and more important and more at risk, the importance of having a C-suite person in charge of data security has become more important. So there's not a long history and experience to draw on. Then secondly, the fact is that in a number of situations, and certainly maybe more historically, the predecessor, if you will, of the CIO or the CISO was more of an IT manager, if you will, someone who was extremely well-versed and knowledgeable about the technology, but was not typically a person who, certainly not on the board, and who met with the board on a regular basis or reported to the board. In some instances, did not necessarily even report to the CEO. And so between those two, taking those two situations in conjunction, there's not much history from the CIO or the CISO's side to know how best to present information, technical information to the board, and the board to know how to receive it, particularly when you have a board where the members have been in place for a number of years. So that's the backdrop or the landscape for preparing and forwarding and communicating extraordinarily important information to a board for it to make its decisions. And it's an extremely difficult situation. It's getting easier. The communication, saying it needs to be clear, is inadequate and insufficient. It needs to be concise. It needs to be succinct. And it needs to be understandable and memorable. People are advised to be prepared to give an elevator speech if they want their message to be conveyed and remembered. And in my view, that's also the case in a communication between a CIO and a CEO, or the CIO and reporting to the board. The difference is the elevator needs to go at least 30 floors, and it needs to be prepared to stop 7 or 8 times. But in that time period, the CIO or the CISO needs to be able to convey to the board or the CIO the different high-level points that would relate to the fact that the company has prepared, that it's planned for its security, and it's prepared to respond to a breach. And the board increasingly is capable of asking the questions, or in most instances referring the issue to a specially appointed committee that's capable of asking the questions, to follow up on those points to the extent that they feel that they need to.
See, that's a huge point I think you made, and I want to expand on that because I think this is part of the problem. Is there now you say your boards are capable of asking the questions. I'm assuming capable of asking the right questions that are valid and useful for the business. Because I think it's an interesting challenge because you won't have a board member saying, I don't really understand this income statement and balance sheet you're showing me. They might not understand it because the numbers don't make sense, but they don't understand the framework or they know how to get more information by drilling into the general ledger. It's all supportable items that they learned in school and in business. And so they can ask questions accordingly. But however, how are they being trained to ask the right questions for an area that is largely undefined?
Several sources. One is the CEOs are increasingly knowledgeable, and the COOs in particular are increasingly knowledgeable and can report those to the board. Part of it is anecdotal. Part of it is talking to their fellow directors for other companies, and some of it is just learning terms from the media. For instance, it wouldn't be atypical at all now for a board member to ask a question such as, do we have a data breach response plan in place, and in your view, is it adequate? Well, that sounds like a very high-level, not particularly helpful question posed to a CIO or a CISO, but from looking at this from a board member's perspective, that's down into one of the 2 or 3 or 4 most important high-level points of a data security plan. So while the board member won't ask and won't care and won't know the details of the plan, they do know and they understand that the SEC, for instance, wants to make sure that your breach response is documented. Not just that you have it, regardless of how good it is, but that in fact that it's written down somewhere. You may remember that relatively recently, may have just been this past summer, the SEC instituted one of its very first enforcement proceedings against investment advisement firm, I think that was R.T. Jones Capital, and by all accounts, its response to the breach was near exemplary. But it still got fined by the SEC for, among other reasons, the contention by the SEC that its response plan wasn't adequately documented in advance. And so boards read things, and they're advised by their lawyers about developments like this. And so it's not an unreasonable question at all, and certainly not unreasonable to think that a board member would ask the question, well, what about us? Do we have things documented? If we have a breach, not just does anybody know what to do, but is it written down somewhere? Because I have heard about this case where an investment advisor was fined because they did not have anything written down.
No, that's a fantastic question, I think, and that gets to, like you said, it's one of the tide rises all boats. It's one of those tide items that will rise. It'll do the brand due diligence, it'll protect the brand, protect the company. It's definitely a necessary question. And you mentioned it's one of potentially four. Is there a source that you refer people to go find out the other three, or is that something that just you have developed, kind of what you think is the top 4 or top 5 board questions to ask? The board asking the CISO, like, do we have a data breach response plan? If the board could craft the best 4 questions to ask for, and again, a lot of the listeners are going to be not the more mature organizations, and I say that loosely because there's plenty of mature organizations that are being breached these days. So, but the more lightly staffed organizations that don't have the depth on the bench, so to speak, the CEO could literally slide these questions to the board and saying, here's the top questions we need to be asking our IT leadership.
Sure, and I would start with the first question that a board member should ask, presumably to the CEO, is, do we have someone who is knowledgeable and capable and competent in place to be responsible for this area? Obviously, the larger the company is, the less that's a concern, but it's still the first question that the board should ask, which is, do we have someone in charge who knows what they are doing? And then secondly, the question should be, and is that person getting the support that he or she needs to do his or her job? Do they have the staff they need? Do they have the technology tools and hardware and software that they need? Are we supporting them for them to be able to do what we obviously understand is an increasingly critical part of our business? That's what a board should start with, and what is within the responsibility of the board is not to make staff decisions, but to make sure that management is asking the questions and determining that you do have adequate resources, meaning especially personnel and resources to look after the intellectual property and the intellectual assets of the company.
I think that's great. And I'm really excited that we went down this path with the board questions, because I just wrote an article called Are Boards Suffering from Ivory Tower Syndrome? I called it ITS. And it was kind of a tongue-in-cheek, and I certainly don't mean any disrespect to board members, but it's got to be a little challenging for them to come out of a very high-level position and ask appropriate questions in an area where there's not like an AICPA, or there's not like a bar association to set some sort of a standard. There's many. Every regulatory agency thinks that they have one. So it's fairly complex and challenging for a board to navigate.
Well, and particularly, I would say, and in fairness to board members, it's not their area. It's not the area of expertise. It's not the reason they were brought on the board. If you have a CIO or a CISO on a board, obviously there's your transition. But if you don't, and it would not be typical for that to be the case, then this is an extraordinarily broad and complicated area. And using your example, while a board member may not be an accountant or a CPA, he or she understands a financial statement and knows enough about a financial statement to ask high-level questions of the CEO or the COO to get some confidence in the reporting accuracy and comprehensive nature of the reporting of the company. But it's not their job, and has never been their job, to monitor or oversee the plans and the processes and the personnel for securing the intellectual capital of the company. So they're charged with a responsibility for which they're typically ill-equipped. They're learning to ask more questions, and appropriately so, they are appointing committees that have more expertise, oftentimes the audit committee, to ask the harder questions or the more detailed questions. And it's particularly important in this area, in my view, in that someone needs to be able to judge the accuracy of the report. That's not to impugn the integrity or say that the CIO or the CISO's report isn't right, but it's important from the SEC standpoint, for instance, that someone checked to make sure that the information was right. And if the board, or in these cases the committee, aren't capable of asking the questions or assessing the accuracy and completeness of the answer, then it's more of a pro forma exercise than it really is a check on the adequacy of the company's coverage of its cybersecurity issues.
Well, Tony, I've really appreciated our conversation today, and I just have one final question for you. And I'm dying to know a little bit about, I read that you're an Eagle Scout, and so I'd love to hear your perspective on what being an Eagle Scout has given you throughout your career, from the formative days when you achieved it to looking back, what you feel you learned by having gone through the process of becoming one.
Sure, and I'm going to start this, and I'm afraid I'm not going to be able to finish it, but from my memory, we are supposed to be trustworthy, loyal, helpful, friendly, courteous, kind, obedient, cheerful, thrifty, brave, and reverent.
That's pretty good.
And as an Eagle Scout, I believe the number was 21, whatever the number of merit badges that you had to have to, as a precursor to being an Eagle Scout, covered a large number of areas, and you didn't need to be an expert, thank goodness, for me to get my cooking merit badge, but I had to know enough about each of those areas to be a well-rounded person that would enable me to achieve the rank of an Eagle Scout. As a lawyer, and particularly as a business litigation lawyer, that's what we're known for. We are someone who knows a little about a lot of things and not much about anything. And so for instance, we're good at parties as long as we don't have to talk to one person for a long period of time. And so we would refer to ourselves as Renaissance people because we know enough about enough areas to ask the right questions and then refer a matter to the subject matter expert.
Gotcha. Interesting. Well, that's great. Well, I really appreciate our conversation today. And do you have any comments or any parting words that you want to share with the listeners as we wrap up for today?
Sure, and I will say this is at the risk of either being found to be a genius several years from now or just foolish. What I have observed over the last few years, obviously there's been the rise in companies of the compliance department. And a lot of companies have CCOs, or chief compliance officers. Similarly, large companies have begun to appreciate the importance of someone in charge of the data security, the CIO or the CISO. From my perspective, what I see is that it is increasingly difficult to separate those two jobs. You can't think about data security in a company without it being in the context of compliance and regulatory requirements. Similarly, you can't focus on the compliance aspects of a company without taking into account the efforts and measures and commitment to data security. So I say that as background for I would not be surprised that those two positions will eventually merge, and I'm going to coin the term of CISCO, CISCO.
Oh, that's cool. CISCO, CISCO?
CISCO, Chief Information Security and Compliance Officer.
Ah.
And that he or she will be responsible for that area because they are indistinguishable. Certainly there will be people on each side of the house, so to speak, who will focus on one side or the other. But from a board perspective, a board is not going to want to distinguish between a compliance report and a data security report. They want to make sure that the company is in compliance with the laws and regulations and ordinance that govern the company, and that its intellectual capital is preserved.
Yeah, and the issue now, is, in my observation, Tony, is that there is a gap between checking a box that you're compliant and actual real security. And is that what you're saying? The board is not going to want that gap anymore?
They're not going to want it. They're going to understand whether they have it or not, and they will be concerned both because of their interest in and concern for the company, but likewise for their responsibilities as board members to do the appropriate due diligence. And just like the SEC is saying, board, you can't just pass off responsibility for data security to an IT, quote unquote, an IT department. The board understands it can't pass off responsibility for compliance with Sarbanes-Oxley or any other, so to speak, non-data security regulatory requirement, and the data security regulatory requirements, even if it's something as relatively mundane as state breach notifications. The board is not going to get down into that level of detail, but it will be critical to them to know that somebody is looking over those areas, and they would want to look to a person who can do that.
Well, I think you have the title of your new blog post for next week, Tony. It's the rise of the Chief Information Security and Compliance Officer.
I would trade you that as long as I will allow you to have, instead of the TS, I think you said.
Oh, ITS, Ivory Tower Syndrome?
You can have the IBS for irritable board syndrome.
Oh, I like that one. That's good. Oh, that's very funny. Oh, my goodness. I like that even better than ITS. Well, it's been a pleasure today, Tony. I appreciate you for your time. Thank you.
You're welcome. Thank you.
So this wraps up episode number 32 with Tony McFarland. I want to thank all of my listeners. I appreciate you very much for taking the time to listen to this podcast. And if you want to follow up with Tony and read more specific information that he's publishing, go to the show notes page at redzonetech.net/podcast. Again, that's redzonetech.net/podcast. I appreciate you for listening and look forward to the next episode, number 33. So there you have it. This wraps another episode of Bill Murphy's Red Zone podcast. To get all the relevant show notes, please go to our blog at www.redzonetech.net/podcast. Additionally, make sure you go to iTunes and leave your comments in iTunes about the show. This helps our show rankings enormously and it helps support the show. Until next time, I appreciate you very much for listening. Thank you.